Okay, we are recording. Thank you all so much for joining us today. My name is Elise Zawacki, and I am one of the council members of ASLABA, which is an acronym for the Entertainment Sports Law Austin Bar Association section. I'm so excited for everybody to be here and really glad to have our three panelists here joining us. I think this is an extremely hot topic, an extremely controversial topic from both sides. And I really just want this to be more of kind of a fireside chat. I've got some pre questions that I've come up with, but if anybody in the audience has questions about this subject, please put them in the chat and hopefully we can get to those as well. I'm going to give a quick overview of each of our speakers. We do have Oren Braca here. Oren is the William C. Connor Chair in Law at the University of Texas School of Law. He is a legal historian and an intellectual property scholar. His fields of interest include intellectual property, legal history, law and technology, and private law theory. Braca's work focuses on intellectual property law, including both the history of the field and its contemporary institutional design, theory, and policy. His book, Owning Ideas, The Intellectual Origins of American Intellectual Property, 1790 to 1909, explores the history of the emergence of intellectual property in the United States during the long 19th century. It has been hailed as a superb study on the transformation of American copyright and patent doctrine in the 19th century, deeply researched, finely nuanced, and lucidly presented. Thank you, Oren, so much for being here today. I know that you're also working on a paper on this topic. Do you maybe want to give us a little bit of an overview about that?
I'll keep it short because the paper at the moment is mainly in my head, but it's very topical. Maybe we'll get to talk about it. So my paper is actually mainly on the infringement side rather than the copyright right side of the debate, and there are pretty interesting stuff there as well. Maybe we'll get to it during the conversation.
Awesome. Thank you so much. We have Julie McCall-Folks with us as well. Over the years, Julie's practice has included software license interpretation, software audit defense, issues involving privacy and network security, and copyright and trademark infringement. Julie has defended clients in more than 250 software audits involving Autodesk, Microsoft, Adobe, IBM, and Oracle. Today, she leads her clients through the software licensing process from procurement to audit defense and everything in between. Known as the commander inside of the firm that she works with, Julie is comfortable taking the lead and lead the role in major transactions and disputes. Julie, thank you so much for joining us. Anything you want to add?
Thank you for having me, Elise. I really appreciate it. I am working with my law partner on a paper that's soon to be published on the copyrightability of AI. And so stay tuned for that work that will be distributed shortly.
Awesome. And we're definitely going to touch on that today. So looking forward to hearing your thoughts. We also have Dandelion West-Manet. Dandelion wears many hats, including those of a generative artist, software engineer, dancer, and researcher. Their professional career has ranged from developing deep learning infrastructure and algorithms as part of Google Brain and co-creating the QQL, an NFT generative art project alongside generative artist Tyler Hobbs. Dandelion, thank you so much for being here. I'm really excited to hear the artist perspective on this because I feel like as attorneys, we kind of get stuck in a little bit of a legal bubble. So it's always good to hear a different perspective.
Cool. Yeah, thank you for having me. It's I've worked in this space from a couple of different angles, but never the legal side. So I think it'll be interesting to bounce ideas here.
Awesome. All right, well, we might actually start out with a question for you, Dandelion. You're a generative artist. Can you explain what generative art is and how maybe it's different to works that are created by these AI tools that we're seeing, such as ChatGPT, DALL-E, or Midjourney?
Sure. So generative art is kind of, generally speaking, it's art where the artist is coming up with like a defined system, a strictly defined system for producing the art. And so a good example being where the artist creates an algorithm and the algorithm then creates art. And so two examples would be, Tyler Hobbs, for instance, made this project called Fidenza that basically puts these long flowing shapes in a flow field, and you can Google it, Fidenza, and you'll see there's lots of variation, lots of different color choices, lots of emotional variation. But this is a system where Tyler has kind of hand-tuned every specific decision around how the software draws every pixel. And so I see this as very directly, and immediately kind of coming from the mind of the artist. Whereas with these AI systems, it's a little bit harder, I think, to say who the artist is. Say that I'm using Stable Diffusion to say, make me art of a rabbit jumping around in the style of Van Gogh. Well, in a certain sense, it's hard to say how much this is really my art, because it's well, I'm using the style of Van Gogh that I don't know how to paint, but the system has learned through looking at all those training examples. And so I think it's pretty straightforward for me when we're looking at generative art, because the artist is it's entirely a creative loop with the artist, and software is just a sort of rigorous tool. It's not so different from a paintbrush. Whereas if I use an AI tool, it seems a little bit more almost like commissioning someone else to make the art. It seems a lot less straightforward.
Yeah, and I think it's a really important distinction, because looking at how much input the artist is having when these things are being created is so important. And as far as generative art goes, I mean, there have been lots of copyright registrations that have successfully been registered for copyright generative art projects, right? And so as these AI tools are coming up and we're having these discussions about ownership and how much creativity has to be input, it is maybe not intentionally, but affecting how we maybe assess generative art as well, and looking at ownership aspects of that as well. Talking about the ownership and all of the questions that we have about this, and Oren, this may be a question maybe geared towards you or Julie. To what extent can AI-generated works be considered original and subject to copyright protection? And how do these new systems kind of impact the traditional notions of authorship?
Should I go first, Julie? Well, maybe you should go first.
Please do.
Okay. Sorry for jumping in. Well, that's kind of a big question, right? And the short answer is that a lot of it is still up in the air, in the process of being debated and decided. But to try to put a little bit of structure into it, I think in terms of copyright law, there are two different issues here. One of them is the one you mentioned, Alice, which is originality and the originality requirement. But even more important, and that's where much of the debate is right now, is the question of authorship, quite distinct from whether the work as a work is original. The question is whether there is an author, whether copyright law requires such a thing as an author, and whether that author has to be a human being, right? That's what's up in the air right now. And I'll try to keep it short. There's much more to say about that. But focusing on that authorship requirement, currently the Copyright Office takes a very strong position that refuses to register works that do not have a human author. So they insist on a human author. And again, part of the legal debate is whether there is or should be such a requirement. In copyright law, there's at least one case being litigated right now where this practice of the Copyright Office is being challenged. What's his name? Stephen Fowler is the person who's the plaintiff in that case. He petitioned to make the Copyright Office register him as the author of a work that he concedes was completely created by an AI he created. So that's being litigated right now. I'll just end by saying, to my mind, and actually even more interesting front is what the Copyright Office is doing on the ground, which is having to negotiate this very, very thorny question of authorship. Even under their requirement of authorship, they're faced with complicated cases. As Dandelion already began to describe, there are all kinds of hybrid cases and cooperations where it's not clear, who exactly is the agent behind the final creation. So the Copyright Office right now has to negotiate it on the ground, and they've already started doing that in specific cases, applying copyright law, applying the idea of thin copyright, where copyright only applies to protectable elements, or in this case, elements created by a human. So much more to say, but I'll stop here, I guess.
Yeah, I'm definitely getting monkey selfie flashbacks whenever I start talking about these types of cases. Julie, anything to add?
Yes, just to add to what Oren said, I think it's an interesting evolution. And so, for instance, in February, at the end of February, the Copyright Office revisited a copyright that it had issued for images that were generated using Midjourney, solely generated from Midjourney, and determined that there was no requisite human author and that those copyrights should be revoked. And then almost exactly 1 month later, issued actual guidance for seeking copyright registrations on material that contains AI generated content. And so obviously, as Oren said, the Copyright Office has been very, I think, stern on saying we are not going to allow protectability of solely AI generated content at this time, but to what extent will we allow the protection of content that's generated in part by using AI generation tools like ChatGPT? And so I think the evolution of those issues is going to be quite interesting.
Right.
Let me perhaps give a quick concrete example on that, what Julie has just been talking about. So in February 2023, right, a few months ago, the Copyright Office, after a very long back and forth with a particular case of registration, on the one hand, stuck to its position. There's necessary requirement of human authorship, but again, it did this more subtle analysis. So with respect to a comic book made out of images created by Midjourney, I think it basically issued a registration with a qualification, right? Saying the images themselves cannot be registered because they were not produced by a human, but we're registering copyright to the selection and arrangement of the images that was done by the human author, as well as the text. So it's on that subtle level that a lot of the issues will come out right now.
Right. And I mean that the implications of that for the artist of that graphic novel is that anybody could potentially take the characters, right, and reproduce derivative works, if that is what the Copyright Office is kind of sticking to. The other thing I wanted to touch on is that the creator of the AI system, they are able to get copyright in their code, correct? It's more these output images that we're having these discussions about.
Yes, that's correct. So software code, object code, and source code can all be protected under copyright.
This is correct, but of course with the caveat that we already have a case about code written by AI, right?
Correct.
Mm-hmm. Awesome. Dandelion, how do you approach the use of algorithms in your generative art practice? And how do you kind of balance this creative input versus what the machine is adding to your creation?
So I'll say first that I'm like not a super experienced generative artist, or I like don't have like a deep personal practice, but I've worked closely with a lot of them. So I think I can kind of like speak from that perspective. I mean, I think that if we distinguish between algorithm and AI, like generative art is all about algorithms. And I think that a lot of what makes it exciting is the kind of unexpected outputs, the surprises. But I think that it is a lot more akin to traditional art methods where, you can come up with like a new approach for painting or for doing a watercolor, say, and then as you're experimenting, accidents happen, and most of those accidents are kind of interesting, but maybe some of them really like get you thinking, and then you kind of evolve a new technique from this idea and just keep running with it. But I think that it once again, it's like, it feels pretty different when it's a closed loop of just like a single well-defined definite tool like a paintbrush or like an algorithm, where I think these are more akin as opposed to an AI approach. I think that my sense is, if we like the way that I would naturally orient on this discussion of like copyright in the more like generative AI system direction would be to think about it kind of from first principles of like, well, if we're defining this legal system, what do we kind of want it to do and why? And like what interests are we trying to protect, and like what are the kinds of outcomes that we could say, okay, clearly this outcome makes sense, clearly this outcome doesn't make sense, and then try to like integrate across that to a more coherent outlook.
And is it possible with some of these AI tools? I've played around with ChatGPT quite a lot, but not so much with the image ones. Is it possible that two people could put the same prompts into these systems and get the same output, or is it completely, different every single time? Do you know?
So I think that it kind of depends on how the system is set up. You could totally imagine software does tend to be deterministic and reproducible, like kind of by default. So if I've got the same model snapshot with the same weights and you give it the same prompt, then you would get the same output over and over. But you can also easily imagine the system, if it's an online system that's kind of getting continually updated and maybe it's got some random state that's shifting around, then you could imagine the same prompt giving different results. I imagine that probably like in the longer term, as we move towards a more like evolved version of these tools, there will probably be a lot of personalization, where if I'm going, even if you and I started with the same model, but it's kind of learning as I'm working with it, what kind of outputs I'm trying to get based on the feedback I'm giving, pretty soon we'd be getting divergent results for the same prompts.
Awesome. Interesting. We've talked a little bit, or mentioned, Oren, you mentioned one of the current kind of pending cases. Are there any other pending cases or legal precedent that we have to stand on here? I mentioned the monkey selfie case. I think that may be even used as precedent here for the machine learning aspect or machine ownership aspect. But Julie, Oren, any thoughts? Any other cases we should be keeping an eye on?
I definitely think that the one Oren mentioned is at the forefront. I think that these copyright determination cases are all going to be very important and are, they're evolving very quickly. I know that the recent copyright guidance on copyrightability of content containing AI generated content is likely to produce many cases and arguments following that. Oren, do you agree?
I certainly agree. I'll just say quickly, again, there is this distinction between the authorship rights side, that is whether there are rights at all in AI generated expressive content, and who gets the rights. So that's one side of the issue. And the other side, which is also rapidly developing, is the infringement use side. To what extent various kinds of uses or outputs in AI generated content infringe copyright. So I take it that the question right now is on the authorship side, because as I said, on the infringement side, we already have at least 3 cases in motion. On the authorship side, that's right. The main case, which is relevant right now, is the Thaler case. By way of precedence, we don't have anything obviously directly on point, but we have the monkey selfie case, right? So to those of you who have no idea what the monkey selfie case, it's that case where a photographer gives a monkey a camera, does nothing else, basically. The monkey snaps a selfie of itself, and then copyright is asserted not so much by the photographer, but by PETA, the People for Ethical Treatment of Animals. They actually take it to court and try to assert copyright on behalf of the monkey. And eventually both the trial court and the Ninth Circuit dismisses that. But obviously there are ways of trying to distinguish a monkey from AI, but that's one precedent out there. Then the other one, which is kind of amusing to cite, but that's the second precedent out there, is the spirit creation case, right? So there is that case from the late 90s where an author of a novel, I think, asserts that the entire novel was dictated to her by spirits from another dimension. Right, so that's an authorship case, and for obvious reasons, the court dismisses that one. Now, finally, a case that seems perhaps more remote, but actually goes to the more nuanced questions, exactly in cases of like Dandelion is describing, of some human creation and some cooperation between machine and human and various hybrid cases. How do you know who's the author, right? What is the criterion for having authorship there? So there is a bunch of cases. It might be interesting to mention just one, which again, different context, but at the end, the principles are relevant. There is the Kelly case from the early 2000s where an artist, I'm blanking on his first name, named Kelly, basically designs the planting sequence within huge areas in one of the Chicago parks of how plants, flowers are going to be planted. And then asserts copyright in that. He actually wanted VARA rights under 106A. And the court has to decide, well, part of the question, there was fixation issues, but the other side of the case was whether there's authorship there, basically. And in that case, interestingly, the court, I think it's a borderline case where the court says, no, there's no authorship because nature is the author in that case. It's nature that really controls the patterns and the growth, despite the initial design.
Yeah, so interesting. I think one of the other cases that was brought up by counsel for the artist in the latest copyright authorship case against the Copyright Office was a photography case where they kind of were comparing these AI tools to, well, if you have a camera that's a machine and the author is telling it to zoom in and how much exposure it's going to have, that's akin to the prompts that you're giving to an AI machine. And so if a photographer can have ownership in the photograph, then why can't somebody have ownership in these outputs based on the prompts that they're giving them and the parameters that they're setting for the AI tool, which I thought was a very interesting case to rely on, right? Going back to such an old case and kind of getting back down to the foundation of authorship and machines, even though this is a newer type of machine than a camera, obviously.
So, as you said at the beginning, Alyssa, I'm a legal historian, so I cannot help myself saying something about photography. Yeah. As people might know, there's a very interesting history to photography and copyright. And I'll give you the short version. Early on, mid-19th century, the consensus position was photographs cannot be copyrighted because they have no authors, basically. Why? Photography was widely understood as the pencil of nature. It was sort of a technical domain where very skilled technicians use technology in order to get nature replicate itself. So there was no human authorship involved. Gradually that erodes, and the famous case is the Barogaz case from the late 19th century, which is completely misunderstood because the Supreme Court there says that a particular photograph could be copyrighted, and that later on is cited as, you see, photographs could be copyrighted. In fact, the Supreme Court there says in very, very discrete, limited set of circumstances where the photographer, like Napoleon Serroni in that case, is really an artist, when he sets up the scene and the costumes and the poses and everything, then you can copyright it. And then there's an erosion process until by the 1940s, we get opinions from learned hand that say it's hard to imagine a photograph when there isn't some original expressive contribution of the photographer. And that's more or less where we stand today. So there is a certain evolution there, which might apply to this context as well.
Interesting. Julie, anything to add on that?
I was just going to say from another perspective that it's interesting how the analogies are drawn. And so when we were researching and writing our paper about the copyrightability of content that contains AI generated content, one of my partners said, this is just like using spell check. Using ChatGPT is just another technological tool. It's just like using spell check. And nobody would argue that the use of spell check would render something unprotectable because there's no human author. And so it's very interesting how people are trying to draw these lines using technology and what constitutes a tool and what constitutes something that is generated by the technology itself. And so I think that knowing the history as Oren does brings it all into focus for me, because we see the evolution and how technology, sometimes when it's new, as this AI technology is treated one way, and then it evolves to where it becomes treated in a different way.
Yeah, by the way, I think the spell check analogy is deeply flawed. I think there's
Me too. Me too. My response
Those are the kind of
was
analogies.
heated and very, very loud. But there can be components and there can be parts that I think Oren mentioned. Is it arranged? Are there components of original content? Is there substantial revision? I mean, a lot of times these AI generative tools like ChatGPT, they're wrong. They collate all the information, and what they produce is wrong. And I did an experiment where I asked the ChatGPT to generate for me whether it thought that the output could be protected by copyright. And the legal conclusions that ChatGPT drew from my prompt were all completely wrong. In every way wrong. And so, for me to be able to use that material in any way, I would have to substantially rewrite it to actually incorporate existing law and precedent and apply it in an actually compelling way. And ChatGPT just can't do that, in my opinion.
Right. And I mean, we may have tools that get better at that in the future, right? But I totally agree. I've definitely played around with ChatGPT a lot, and it will lie to you. I've seen some screenshots of people having conversations, and it's so convinced that what it's saying is correct, which is quite funny to read. I don't know.
And I think sometimes at least the ChatGPT hits on the second prong that Oren was mentioning earlier. So it's not necessarily, even if you could get past the human authorship hurdle and argue that the authorship is in some way human, or a work made for hire, or using one of those concepts, I think you're going to have a problem, particularly with the verbal tools, maybe not as much the image tools, because a lot of the material that it's using to process is in itself copywritten. And so you never know whether the output is a paraphrase of material that's already protected, or whether that material that has been generated is verbatim protected material. And so if you trying to seek protection on that material may be problematic, because it might not be original either.
I don't want to monopolize too much time, but let me just put it on the table, and something very interesting in what Julie just said. There's it's not a widely observed issue, but there's a very complicated, both technological and legal and conceptual issue with the issue that Julie just described, which is as follows. It's not even clear that in even the most obvious cases of copying by AI, when you say, give me the lyrics of Bohemian Rhapsody, and you get the lyrics of Bohemian Rhapsody letter by letter, technically speaking, it's not clear that the process involved is the process we ordinarily think of as copying. What actually is going on, from training to what's going on in the belly of the machine, is not what we usually think about as copying. And one could, even if we wanted to push it, could describe it as a form of independent creation, which raises a whole lot of questions about what's copying anyway, but also the more fundamental questions of why do we restrict copyright to copying and don't include independent creation in the first place. I think that's one issue that eventually will also float here to the surface.
Yeah, and I really want to get into this infringement side of things. We've gone pretty deep into the authorship side, but concepts of fair use and using other people's artwork. Dandelion, have you, that you know of, had any of your work or know of anyone who have had outputs from these tools using your artwork, or anyone that you know?
Not personally, no. Generally in the generative art side, there's not a lot of there's not a lot of like copying of like people's work happening in this sort of like raw, because people are working on the algorithm level. People can kind of like copy each other's like algorithms at a concept level, but it's not as susceptible to this kind of like AI copying regurgitation. But I'd actually like to just comment on the aptness of the photography metaphor, if I may. Yeah, I think that the camera and the photography is actually like really a perfect metaphor for this case, because we're seeing a sudden discontinuity in the amount of effort required to produce something, where it used to require a lot of effort to produce like beautiful visual representations of scenes, and then all of a sudden it becomes, you know, just like in the limit. Obviously today, push of a button. Clearly there were a lot of intermediate steps. And I think that when there is this like 100-fold reduction in effort and this massive expansion, and there's an apparent devaluation of a very developed skill set, there's a temptation to say that there's no longer any like work or creation happening. But I think that in the same way that it turns out, okay, we got better technological leverage on being able to extract information that was in a sense already there, right? The visual world is already there. It just used to take a lot of work to render it. I think that it is a really good metaphor, because I think that while we might, you know, you can get pretty similar kinds of outputs qualitatively from very different models that were trained on different sets of data. And I think that reflects the fact that in some sense, it's less the uniqueness of the model, but it's more like each model is a different implementation of a camera, but what they are all doing is like photographing into the same shared like embedding of human culture. You know, if you train on corpuses of images produced by humans, like available on the internet, you'll tend to find the similar kinds of patterns and motifs. And so I think that when we, in the same way that like right now, this might, I mean, obviously technology spreads a lot faster now than it did a century ago. But right now it may seem like sort of like an edge case to consider with this AI generated work, given how radically cheap it is and how quickly this technology is likely to deploy, in the same way that now we all have treated as completely ubiquitous. They've got a camera or like multiple cameras they've got access to continually throughout the day. I think we are heading to a world where having massive amounts of generative intelligence is also completely ubiquitous. And so I think that kind of begs the question of just like, what is a coherent world that would actually make sense from a cultural and economic standpoint? And I think we can say, looking back, okay, saying that all photographs are uncopyrightable, or saying that the manufacturer of the camera owns the copyright for every photograph, like there's not really a coherent world, I think, for us from a policy and economic standpoint where that would be the case. And so it feels to me that like it's just going to be a little bit more like we're all incredibly used to the idea that we've hired a personal, incredibly talented artistic personal assistant who's agreed to like waive all copyright and give it to us, because there will be a profusion of different providers that are capable of like offering these AI services. And I think that the ones where they do assign the copyright to the user will tend to be more economically valuable than the ones where it all gets like locked in like one giant legal vault or doesn't exist. So I feel like there's like just by looking at like the shape of the economic structure, we can guess the policy endpoints. As my like non-lawyer like position here.
Sure, absolutely. And I agree. And I think hearing the evolution really kind of makes sense, right? There's always headbutting when new technology comes out, and we have to grapple with these legal issues and try and apply copyright laws that are very old to new technology can be extremely difficult. I think one of the major differences between the photographer example and these new AI tools is that when you're taking a photograph, you're not using pre-existing works to take that photograph, right? And so going and moving more over to that infringement side of things, Oren, how does this concept of infringement and fair use play into all of this?
Yeah, so let me start by giving, I hope, brief and very general overview, and then we can see which part of it we want to take up, because again, that is a universe in itself. There are many, many interesting and complicated questions arising there. But by the way, my view on that is that at the end of the day, good old century-old copyright principles can answer most of those questions as applied to this new technology, at least on the infringement side. But it is an exciting new world. There is a new universe opening up, and therefore people are making a lot of arguments, and sometimes it's hard to wrap your mind around them, and things are in flux, and it's hard to predict what courts will do. But to simplify, I think there are three main different arguments being made in this context. Sometimes they've been, sort of woven together, and it's hard to tell which one is being made, but basically the arguments are as follows. One argument is use of a digital copy of a copyrighted work in the training process, in and of itself, irrespective of anything else, is copyright infringement. So that's what I call, the copy in the belly of the machine, right? In order to have generative AI, by the way, AI that generates expression in itself, or any kind of other AI, including, autonomous driving AI, you need to train the AI. And the learning process basically involves showing the AI a lot of works, very large numbers of works that are likely to be under copyright. Now, the way it works, showing a digital machine a work means making a digital copy of it. There's no other way of doing it. That's how it works. But again, in many cases, nobody else will see those works. It all happens in the training process. And at least that's the argument, irrespective of what happens else. Even if the AI never creates output, which is similar to the training copy. Indeed, even after the training process, you destroy the whole system. Reproduction for purposes of training is already copyright infringement. Okay, so that's one set of claims that is being made across the board, to my mind, baseless and should fail. It's unclear whether it's going to fail or not. Second set of claims is more traditional. And actually, the two other sets of claims now focus in a more traditional way on the output of the AI. Right? The AI actually spits out new expressive material in this case. Could that output be infringing? And one set of arguments is just traditional copyright arguments, which should be familiar from other contexts. Output of AI that has been exposed to the relevant copyrighted work during training, which is now substantially similar to one of those copyrighted works. We know how to analyze that. We might have some questions, just like we have on the side of authorship, about who exactly is the infringer, right? But otherwise, copyright-wise, those are rather traditional questions, with the caveat of what I mentioned earlier, which is, do AI copy ever at all, even when the work was in the training set? Now, finally, a third set of claims is again about the output, but it sort of veers away from more traditional copyright arguments, in the sense that it focuses on arguments like copying of style. Okay, so you often hear the arguments, and in fact, in the stability case, that's one of the arguments being made. Look, I look at the output of certain AI systems. It's not that anything there is substantially similar to any of my works, but the style is my style, right? The subject matter might be completely different. Indeed, it's very likely that the prompt has been, draw me, I don't know, a ship in the style of X. Right, and X never drew a ship, but the AI, because it's so good in picking up patterns, can draw you a new subject matter, really a new substance, but it's very much in the style of somebody. So we've seen those arguments about copyright and style. And again, I just want to put it on the table. I think those arguments as well, basically on grounds of traditional copyright principles, should fail. But it's unclear that they're going to fail.
Mm-hmm. And you mentioned the stability case. Can you just give a brief overview of what's happening in that case? I don't think we touched on that one.
Yeah, I'm not sure I'm completely up to date because it keeps changing daily. So if somebody has better information, correct me. But the stability case is a case which is a class action. I'm pretty sure it is a class action, and it was brought by a group of artists, but, standing for a much bigger group of artists. And their claim is that their work had been reproduced with no authority within the training set of particular AI systems. So it's not just stability. I think it's stability and
Journey, I think, is the
My Journey, and also what is it called, DeviantArt or something like that. The claim is that the copyrighted works, graphic works, had been reproduced with no authority in the training set. So remember that in itself, the argument is copyright infringement. And then there are, in the complaint anyway, claims which are extremely broad and ambiguous on purpose. One needs to kind of read the tea leaves of what exactly are they trying to say. They say it's phrased in a way which is something like the output is derivative of the copyrighted work and compete with it in the marketplace. Why are they phrasing it that way? Because they're trying to go around the difficulty of they don't have many cases, or at least that's not what they're trying to go after, cases of really substantial similar output works, right? They're trying to go after these more diffused general ideas of derivative in the style of the mere fact that it was in the training set and now it competes with me is copyright infringement. So it's that lawsuit, again, on behalf of a big class of authors, and they make the entire range of arguments, from training to specifically similar output works to much broader, more abstract arguments about the output.
Awesome. And Julie, given this question of potential infringement, how are you guiding your commercial clients in using AI-generated content? I mean, are you telling them they should be cautious of it if there's, copyright infringement claims that could be brought up?
I'm laughing, Elise, because several weeks ago I wrote a blog about the use of ChatGPT in commercial settings, particularly for marketing purposes. And my conclusion was, don't ever do it. You should never touch it. Stay away from it. And my law partner went ballistic because he was saying, like, people are doing it. You have to guide them through this. You can't just generally say, don't ever do this and stop using it, stop calling me about using it. So I had to go back and take a more nuanced and, I would say, in-depth road so that I could help them more carefully navigate some of these thorny issues. But I do agree with Oren. There are many issues that are going to arise from the learnings. And I'm going to focus on ChatGPT just because I've been focused on that in my practice lately. Their license agreement, particularly with respect to who owns the content, the customer or the input data and the learnings and the output data, has changed at least 7 times this year. And it is April. And so every time I look at ChatGPT's license agreement and how it's telling its end users that they are not going to be using the input data, the content or the output data, it's brand new every time. And so just from a legal perspective, I am concerned that my clients are using these tools without fully understanding what is going to happen with the data they're putting in, what is going to happen with the data as it's processing, and what is going to happen with the data as it's coming out. And if these folks at AI tool, the AI tool owners like ChatGPT feel empowered to change so rapidly what they're going to do with this output. And in this case, interestingly, it started as ChatGPT owns everything, or the owner, I think it's AID or something. They own everything, right? And then it evolved to where they're only going to own the learnings, but not necessarily the input data. And now it's, we don't own anything, and you can opt out of us using your input data for machine learning, which, first of all, I don't know how anybody could monitor or enforce that. Without just going on discovery laden lawsuits where we don't know the outcome. But secondly, what would keep them from changing it back after they collected all the data? What would keep them from saying, okay, now that we've received all your input data, we're changing it yet again, and now we own everything?
Interesting. And I'd never thought about even the privacy concerns that come along with that, with what you're putting into the system, right? And then how they're being used. Dandelion, are there concerns in the art community about AI tools being used instead of artists? I know that this is definitely from, I work with a lot of artists, definitely concerns that I've had clients talk about. What are your feelings on that? And what have you kind of heard in the art community?
Well, let's see. People have definitely not been like most artists I talk to have not been very pleased about the world of AI, and I think that the like general perception is quite negative. And I think that that comes like from a variety of different sources, actually. You know, one being that there is this issue. Like, I really disagree. I think with the conclusion that like style should not be something you can defend from being endlessly reproduced by AI systems. And I think that like it's just like because I do think that like style is in many sense what the artist is truly creating, and then they're like rendering specific points. But I think that if you were to look at it, for example, generatively, like it's not really any particular fidenza that is the copyrighted thing. It's like the Frodenza algorithm and system. It's like a whole conceptual universe of different images that is Tyler's creation pretty explicitly because it's an algorithm. But I think that if I have a friend who like spends like years developing a really interesting and evocative style for depicting emotions, just like characters or something, if you can just like come and like have the AI system just generate stuff that's indistinguishable from their body of work, I think that'd be pretty weird. And I think that artists are reasonable to be stressed about this. I think that there's also like obviously the broader problem of everything being embedded in capitalism, and the fact that if you're an artist who is trying to make a living through your passion of art by being able to like sell, like in any way get economic value from the art that you're doing, if you are not like a superstar where people are buying it because of your name, but they're buying it pretty much in any sense because of how it actually just like looks in and of itself, like I think that you become economically completely irrelevant in the next 2 years and you need to like get a different job. And that's a pretty rough thing to like ask of people. And so I think that like disruption is upsetting, but I think that artists are merely on the bleeding edge of that. And in truth, like so many people, including so many like people who are quite economically comfortable in the current status quo, are going to be on the same edge of disruption. Like ChatGPT is a very bad lawyer for now, but like where will it be 4 years from now? Like, shrugs, interesting question. Y'all lawyers, though, you're very well positioned to put up regulatory barriers to competition, so you'll do better than most other professions. But yeah, I think that that's kind of my sense of where artists are at, mostly like unhappy. And I think that there's actually a very small number of artists who are super excited because they can see that like actually like there's going to be such like incredible creative possibilities from this. And I think that as with many advents of technology that seems quite scary, it will be very unfortunate and disruptive to those who do not adapt very quickly, but conversely will be an incredible source of opportunity and leverage to those who do. So I think that there are going to be like a generation of artists that really like grok the kind of creative potential that's been unlocked by these tools and will have very fascinating impacts.
Mm-hmm.
Can I say two things about that?
Yeah.
So those are great down the line. Those are obviously highly important, fundamental, and controversial issues. So to try to keep it short, two general things. First of all, about style and expressive universes. Those arguments have been made for centuries now, and there are well-established fundamental principles of copyright which are there, and for good reasons. And among other things, in order to preserve the ability of people to create, that actually tell us, no, copyright law is not about that. It is not about general style. It is not about universes of creation. Indeed, often it is not about the most important valuable contributions of people who create, like the content. For example, Einstein or Newton could not copyright their theories. And all of that is for very good reasons we can talk about. And I don't think much has changed with AI, except one thing that would lead me to the second issue. Turns out AI is so much better in appropriating those things, can do it faster, so much powerful, right? And should that change anything? So that brings me to the second set of issues that down the line was talking about, which is sort of the general issues of AI reflected in the creative realm, right? The concern that, if it gets too powerful and it's too good in what it does, it's going to take away all the jobs and much of the income, and people just, won't have jobs, right? The robots are going to take away everything, like in other fields. That's one concern. Another set of concern is more unique to creativity, which is assume that we live in that world where AI Although again, as Dandelion usefully says, it's unlikely to be just AI. It's going to be probably a little bit hybrid models. But assume that we live in this world where AI and some hybrid models basically supply most of the market demand, right? And can do it more effectively and efficiently. Are we still losing something? And I think the answer clearly we are still losing something, which is human creativity. And what's the value in that? First of all, there is intrinsic value in that, irrespective of market value, right? But there are hard questions to answer and analyze about it. And second, there are also the big questions about where really, so Dandelion was talking about disruption, but this is now expressive, not technological disruptions. Where will the breakthrough come from, right? AI seems to be very good in replicating patterns. It's unclear yet whether it's very good in creating, the equivalent of scientific revolutions within expressive art. Aren't we losing that? So there are big issues there, but by way of just framing the discussion, I'm afraid it's unclear to me that copyright can deal with all of that and is the right instrument that can solve those problems. I think those problems are much bigger than what copyright can and should do.
Yeah, I'm already seeing a lot of my clients with amended their freelance agreements for any artists that are working with them to kind of say that they're not permitted to use AI in the creation that they're doing. So I'm seeing from the other standpoint as well, businesses concerned and wanting to make sure that when they are hiring an artist, that they are getting that human creativity and we don't just have the person going and using one of these tools and delivering it to not only from the infringement concern standpoint that Julie touched on, but also from that human creativity standpoint, right? They want a real artist to be making the artwork for them. All right. I might ask one more question and then leave some time for questions from the audience. So and this is kind of a big question, but what are some potential future developments that you could see further impacting copyright law? And how do you think the legal system and us as attorneys in particular can kind of prepare for this? Julie, I might go to you first.
So I would say the legal system is somewhat slow, particularly when it comes to technology. And, the last copyright case I had in the Southern District of New York, the federal judge that was presiding over the case didn't even use email. And so trying to litigate these concepts in front of folks who not only don't understand these nuances of technology, but don't understand technology at all is somewhat challenging. And I think that we're going to see, at least in the near term, I think we're going to see a lot of bumbling about how to treat these issues. We're going to see people who maybe don't even understand what machine learnings are and are trying to apply traditional copyright principles. Like, there's that line of cases where if you load source code in the RAM of a computer, then that in and of itself is infringement because the source code is protected and et cetera. So you're not infringing the output of Microsoft Office, you're infringing the source code that operates it. I think we're going to see people trying to apply those types of copyright analyses to AI, and I think it's not going to flow very well. And I think that we are going to have a lot of really bad law before we get anything that's actually useful.
Yeah. Oren?
No, I'll keep it short. I concur. B, I actually, as I said, I think there are solid copyright principles that can take care of most of it, or at least give us framework for thinking about it. Whether it's going to happen fast, in the courts, as Julie is describing. Yeah, I'm not very optimistic.
Dandelion, any closing thoughts on the future of AI from the artist perspective?
I guess that I feel like it's so unclear. Like there's just an entirely new structure of power and creativity and change that we've unlocked. And I think that that's going to have probably some really strong, stable attractors in the sense of what kinds of outcomes it produces. We just don't know what they are. And it's just so unclear. I think it's I really don't know. I'm fascinated.
Yeah, I'm fascinated too. Well, we've got about 5 minutes. Does anybody from the audience have questions for our panelists?
Can I jump in real quick?
Yeah.
So first of all, thank you to all the panelists, and I think you need to come back in like 3 months because things will be wildly different. We'll keep talking. But so at least just to follow up on the thing that you were saying, if you have galleries or whomever that are saying to artists, if there's already a rep and warranty from an artist that this is original content and whatever, like how is that changing? And if I'm the artist, am I just determining for myself the threshold? Do I use generative AI in the way I'm using a tool? Or so I mean, I'm curious about like how are you expanding on that kind of artist representation about its originality?
Yeah, Julie, might be a question for you.
Sure. So I'm not seeing at the moment a lot of graphic or image art that are requiring those representations, but I am seeing it in terms of marketing materials. And so when my clients are reaching out and hiring marketing companies to draft their websites, for instance, you have to make a determination about whether that's allowable. And interestingly, in the non-legal field, most of my clients want people to use AI because they think it's faster and cheaper. As Dandelion said, it becomes a commodity. And so I see that many of my clients do not want these representations. In fact, they are encouraging the use of AI, and I have to pull them back a lot. And so I think that's a really interesting and unexpected development. I would have thought, much like Michelle, that we would want a rep and warranty that you're going to be the actual original creator of this material. And a lot of folks are saying, no, it's cheaper and easier if we don't get original content. We just need something fast, and we need something to fill space, and we don't actually care how good it is. And that part to me was quite surprising.
Interesting. Yeah. And I've been seeing mainly the opposite, where I've had, and maybe it's because I'm mainly working with the people who are hiring the marketing companies, but and they're kind of saying, hey, we don't want these people to use AI. We're paying them for a reason, for their creativity, and we want them to originally, create it. But I can definitely see, as it becomes technology that we all use more and more in day-to-day life, that it does become more acceptable to be using it, even if you are hiring a freelancer who may be better at putting prompts in and getting the content that you want out of these AI tools. Other questions? Anyone? All right. Well, any closing thoughts from any of our panelists? No?
We're living in interesting times.
Yeah, absolutely. I completely agree, Oren. Well, we're pretty much right on time, which is awesome. So we will send out the CLE credit via email for this presentation for anybody that wants to claim CLE. I will admit I used ChatGPT for the title of this presentation as well as the description. And I think for presentations such as this, it can be a really useful tool to speed up those processes, especially as attorneys when we're wanting to give a quick overview of something that we're doing. All right, well, thank you all for joining us. Thank you so much for our panelists. This has been so insightful and really great to hear from all of you. If anybody has follow-up questions, please feel free to email me, and thanks for joining us.
Thank you very much.